Consider Harold. He's 74 years old and lives near Medicine Hat, Alberta. A retired pipe fitter, he spent 41 years working honestly. He has held a PAL ever since that licensing system began. Prior to that, he possessed an FAC dating back to 1987. For a longer period than some lawmakers responsible for current firearms legislation have been alive, Harold has remained a licensed, lawful, and responsible firearm owner. Last spring, Harold received a call from his son. Concerned, his son explained that he had read about recent regulations. He believed Harold might be required to surrender a restricted firearm. He also thought there could be a new recertification requirement, and that Harold's existing license might no longer provide the same coverage as before. Those comments stayed with Harold for 3 days. During that time, he wondered whether his son was correct. Perhaps the regulations had changed without him realizing it. Perhaps, despite following every rule for years, he had somehow become non-compliant. He nearly contacted the RCMP to ask about turning over the firearm, but he did not. When Harold finally examined the matter himself, he discovered something that completely changed his understanding of the situation. He was not merely compliant with the law, he was specifically and legally exempt from the very requirements that had caused concern. This was not the result of a loophole. It was not a hidden technical detail buried deep within obscure language. Instead, Canadian law currently contains explicit protections for long-term licensed firearm owners, protections that receive very little public attention. Harold almost surrendered a firearm he was legally entitled to keep, not because legislation forced him to do so, but because he believed information that turned out to be incomplete. That situation highlights a larger issue. Many people remain unaware that certain legal protections are already available to them. One reason this happens is the way firearms regulations are commonly reported. News coverage often focuses on newly announced rules, explaining what has changed and what obligations people may face. What is frequently missing is an equally important explanation. Who is not affected by those changes? That omission can have significant consequences. When misunderstandings arise, the individuals most likely to voluntarily give up a legally owned firearm are often not people with unlimited time to research legal details. Instead, it may be seniors who trust the information they receive, who believe advice offered by family members, and who prefer to avoid even the possibility of violating a rule they do not fully understand. Among Canadian firearm owners, seniors can be particularly vulnerable to acting on inaccurate information and surrendering rights they still possess under the law. Today's discussion focuses on 5 protections currently found within Canadian law for senior licensed firearm owners. These are protections many people have never been told about. They are also the reason Harold retained his firearm and why others may find themselves in a similar position. The first protection involves long-term PAL holders. When Bill C-21 was enacted and additional regulatory changes followed, implementation provisions included a measure that attracted little public attention. Rather than appearing in major headlines, it was incorporated within the regulatory framework itself. Individuals who have continuously maintained a valid possession and acquisition license over an extended period, renewing it on time and without interruption, receive specific procedural protections regarding the application of certain new transport and carrying restrictions. In practical terms, this means that someone who has maintained a PAL for many years, renewed it consistently, and kept a clean record is not necessarily treated the same way as a brand new applicant. The compliance obligations imposed on new applicants do not automatically apply in identical fashion to long-term license holders. Again, this is not a loophole. It reflects a deliberate legislative approach. Canadian courts have repeatedly recognized that imposing substantial new requirements retroactively on individuals who were already complying with previous laws can raise significant charter concerns. Legislators are aware of this reality. As a result, long-term holder protections are often incorporated into new legislation to improve its ability to withstand legal challenges. The difficulty is that these protections are rarely emphasized publicly. For anyone uncertain about how a new firearms regulation affects an existing PAL, one straightforward step is available. Contact the RCMP Canadian Firearms Program at 1-800-7314 and ask a direct question regarding whether the regulation applies to your specific licensing status. Write down this question exactly and ask it directly. As a long-term continuous PAL holder, which specific parts of this regulation apply to my current license? Record the response. Ask for the representative's name as well. The answer may be as unexpected as the one Harold received. Another protection exists under the Canadian Human Rights Act, and very few people are aware of it. This is where the discussion becomes important. Many recent firearm regulatory changes in Canada involve training requirements, recertification procedures, qualification standards at ranges, and demonstrations involving physical firearm handling. That raises an important question. What happens when a 70-year-old individual with documented mobility restrictions, chronic arthritis, a hip replacement, or a hearing impairment is informed that a physical training program must be completed in order to maintain licensing status? The Canadian Human Rights Act forbids discrimination based on disability within federal services and programs. The RCMP Firearms program operates as a federal program. PAL licensing is administered as a federal service. As a result, if a new training requirement or recertification process creates an unreasonable obstacle for a senior with documented physical limitations, that individual may request a reasonable accommodation under the law. Such accommodations can include a modified assessment method, an alternative evaluation format, or a home-based review conducted by a certified instructor. The objective is to achieve the same verification outcome without requiring someone to complete a task that physical limitations make impossible. There's one detail many people overlook. Accommodation is not automatically provided. The request must be submitted specifically and in writing, accompanied by appropriate documentation. If a senior firearm owner faces legitimate physical limitations that make standard training requirements impossible or excessively difficult, that circumstance is not automatically a reason to surrender a firearm. Instead, it may be necessary to understand the accommodation process before taking any further action. When accommodation requests are denied, complaints are handled through the Canadian Human Rights Commission. The contact number is 1-888-214-190. Another protection involves grandfathered classification, and timing plays a critical role. When a firearm is reclassified by the government, whether from non-restricted to restricted or from restricted to prohibited, a grandfathering provision is often included. Grandfathering means that a person who legally possessed the firearm before the reclassification took effect may continue to keep it under defined conditions. The firearm does not automatically have to be surrendered. It does not automatically need to be sold. Ownership of the firearm may continue when those conditions are met. However, this protection comes with requirements. Grandfathered status remains effective only while the owner continues meeting the conditions attached to it. That includes proper registration, lawful storage, compliance with transportation rules, and most importantly, maintaining a valid PAL. If the PAL expires, even for a short period or by accident, the protection attached to grandfathered status can become vulnerable. Grandfathering protects a licensed owner. If a person is no longer licensed at the relevant renewal point, that protection may no longer apply. Because of that, one action stands above all others for senior firearm owners. Do not allow the PAL to expire, even if there is uncertainty about new regulations, even if requirements are unclear, even if options are still being considered. Keep the license active while seeking answers. Once a lapse occurs, the protection that previously shielded the owner from certain new requirements may no longer be available. Renew first, research afterward, never reverse that order. Another area that frequently creates confusion involves the distinction between storage rights and transport rights. This misunderstanding causes unnecessary concern for many seniors. When news reports discuss new carrying or transportation regulations, some firearm owners assume the changes affect firearms stored inside their homes. That is not the case. These are separate legal issues. The legal storage of a firearm inside a residence for personal protection falls under storage regulations established through the Firearms Act. Those storage requirements have not changed. A legally owned firearm that is stored properly within the home remains protected under existing law. Transportation and carrying regulations address a different situation entirely. They govern what occurs when a firearm is taken outside the residence. Requirements involving ATTs, transportation restrictions, or route limitations apply while the firearm is being moved. They do not affect a firearm that remains secured inside a home safe. Consider Harold's circumstances. His son contacted him because of concerns regarding carrying regulations. Harold does not carry a firearm. He keeps it at home. The only times he transports it are trips to and from an approved range. As a result, the carrying restrictions that concerned his son had very little relevance to Harold's actual situation. For Canadian seniors who keep a firearm at home for protection and have no plans to transport it, many of the transportation and carrying rules that dominate news coverage may have little relevance to their personal circumstances. It is important to understand that those regulations exist. It is equally important not to assume they automatically affect every firearm owner. Storage rights and transportation rights are different legal matters. Treating them as if they are the same can lead people to surrender property they were fully entitled to retain. Another protection concerns PAL renewal costs and hardship provisions. This protection is particularly relevant for seniors living on fixed incomes. Maintaining a PAL involves expenses, application charges, renewal costs, potential recertification expenses, training fees, range-related costs, and other administrative charges can add up over time. For someone relying on CPP and OAS, these combined expenses may become a significant burden. What many individuals do not realize is that the federal firearms licensing system contains mechanisms designed to address financial obstacles connected to license renewal. When the expense of maintaining a PAL creates a genuine hardship, there is a process available to address that concern. It is not heavily promoted, The system does not typically volunteer that information. However, the process exists. Canadian courts have recognized concerns that arise when exercising a legally established right becomes financially unattainable because of licensing costs. In Canada, firearm ownership for eligible individuals is recognized as a legally established right. When fees become prohibitive, legal questions can emerge regarding the structure of those costs. Charter-based arguments have previously been used successfully in cases involving licensing expenses imposed on low-income individuals. If a senior living on a fixed income finds PAL renewal costs increasingly difficult to manage, contact the RCMP Canadian Firearms Program at 1-800-7314 and specifically inquire about hardship-related provisions connected to the renewal process. If there is a belief that the fees create an unconstitutional obstacle, that issue may require discussion with a firearms lawyer, as similar legal arguments have succeeded in the past. A fixed income does not automatically eliminate a person's ability to retain a firearm that the law permits them to possess. Financial concerns alone should not become the reason a lawful owner loses something they are entitled to keep. When all 5 protections are viewed together, a larger picture emerges. The central challenge is often not the law itself. It is the lack of accurate information. In many situations, existing legal protections are actually favorable to long-term licensed senior firearm owners. The difficulty is that the people who need this information most often never receive it. Most reporting focuses on what changed. Far less attention is given to identifying who may be exempt from those changes. Consider Harold again. He is 74 years old. He has maintained a continuous firearms license since 1987. He has a documented knee condition resulting from 4 decades of pipe fitting work. His firearms are legally owned. They are stored correctly. He has no desire to transport them anywhere except an approved range twice each year. Under every protection discussed so far, Harold occupies a strong legal position. Yet he nearly surrendered a lawful firearm because of a conversation with a well-intentioned son who misunderstood the regulation he had read. That is the real issue, not necessarily the law itself. The issue is incomplete information. Any senior firearm owner should take steps to confirm their own situation directly. Contact the RCMP Canadian Firearms Program at 1-800-7314 and ask about the current status of your license under existing regulations. Ask whether long-term holder provisions apply. If grandfathered status may be relevant, request clarification regarding that protection as well. Keep written notes of every response. If a physical condition makes training requirements genuinely difficult, contact the Canadian Human Rights Commission at 1-888-214-1090 and request information regarding accommodation rights before making any decisions. Above all else, keep the PAL active. No matter what uncertainties exist, do not allow the license to expire. If anyone, whether a law enforcement officer, government representative, or concerned family member, states that your firearm rights have changed or suggests surrendering a firearm, document exactly what was said, who provided the information, and when it was communicated. Before taking action, seek legal advice from a firearms lawyer. The National Firearms Association can be reached at 1-807-90167. The organization maintains legal resources for situations involving alleged misapplication of regulations or incorrect enforcement actions against licensed owners. Harold kept his firearms for a simple reason. He learned what his legal rights actually were. Those rights were clearly established. They existed all along. The problem was that the complete information never reached him until he looked into the matter himself. If this information may help someone you know, share it with Canadian seniors who legally own firearms. Many of the people who could benefit most are not actively searching for answers. Instead, they may be relying on incomplete information and could be only one conversation away from giving up something they are legally entitled to keep. Take the time to verify the facts, document the answers you receive, and understand exactly which rules apply to your own situation before making any decision.